A very good evening, distinguished guests, ladies and gentlemen. My name is Shannon, and on behalf of NUS Law, I'm delighted to welcome you to the Tjio Koh Professorial Lecture. NUS established the Tjio Koh Professorship in honor of the late lawyer and philanthropist, Mr. Koh Chun-ju. Established in 1996, the professorship was to enable the Faculty of Law to engage distinguished legal experts who will teach and participate in research, bringing their knowledge and unique perspectives to the NUS community and to Singapore to further its ever-growing regional and international role. The professorship is supported by a generous gift from the estate of C.J. Koh, and we are extremely pleased to have with us today Mr. Tan Suan Heng from the estate of Mr. C.J. Koh. Professor Tjio has held the appointment of the C.J. Koh Professorship since 1st July 2019. Widely respected in the legal profession, Prof. Tjio is an authority in company, securities regulation, and trust law. Today, Professor Tjio will deliver his lecture on the nature of entities, restructuring REITs and business trusts as unregistered companies. The chairperson for today's lecture is the Honorable Justice Chua Lee Ming, Judge of the Supreme Court. It is my pleasure now to invite Dean of NUS Law, Professor Simon Chesterman, for his welcome address. Dean Chesterman, please.
Thank you very much indeed, Shannon. Justice Chua Lee Ming, distinguished guests, ladies and gentlemen, it is a great delight to welcome you here in person, and we've been saying that a little bit more frequently, but possibly for the last time wearing masks, which means that there's a future in which I might see whether you're smiling at me or frowning at me, but I know Hans might take some comfort in not being able to read anyone's expression based on what he's saying. It is always a delight to recognise the achievements of one's colleagues, and really that's one of the highlights of being dean of a great law school like NUS, being able to celebrate when colleagues do well or are given honours. And this professorial lecture is an opportunity to celebrate Hans and his work. Hans is such a kind, low-key individual, such a committed teacher and mentor, and I see many people who've benefited from that in this room, that it's sometimes easy to forget how influential he is, both in the profession as well as academia. Over the years, he's also distinguished himself as a leader within the E.W. Barker Centre, where he epitomises the idea of servant leadership. That is the idea that leadership is an opportunity to create opportunities for others, to help them thrive. And again, many people here have benefited from that over the years. Hans will get a proper introduction in a moment, but before I hand over to the chair, I did want to acknowledge the donor who made this chair possible, C.J. Koh. As Shannon has described, we've benefited from that support in many ways. And NUS as a law school, we do benefit a lot from strong government support. We know our students pay significant fees as well. But as we aspire to being one of the very best law schools in the world, while also ensuring no deserving student is left behind for financial reasons, we do need additional support. I never had the privilege of meeting Mr. Koh, but his legacy at NUS Law is clear. In addition to the chair that Hans now holds, our students study in the C.J. Koh Law Library, a name that it's held for more than 2 decades on 2 physical locations. Mr. Koh has also supported scholarships and other initiatives that have had a tremendous impact on legal education and research, and we're grateful to have Mr. H.H. Tan here today, continuing to maintain that legacy. Among other things with a book, which I think at the last time you were here, we were talking about that book, and now it's great to see that book in print. But now on to the main event. To introduce Hans, we're delighted to have Justice Chua Lee Ming here with us, a graduate of NUS Law in 1983 on the other campus. We've just established, we think, that he overlapped with Hans at Cambridge while the judge did a master's degree there in 1988, but they appear not to have met at that time. We can figure that out over drinks later on. Justice Chua worked in the courts and at the Attorney General's chambers until heading to private practice in 1990, becoming a partner at Lee & Lee. Public service was calling, however, and he joined the Government of Singapore Investment Corporation, or GIC, in 1998, rising to become General Counsel. And among other things, he was a founding member of the Singapore Corporate Counsel Association. He went to the bench in 2015, and it's a pleasure to welcome him back to his alma mater, to NUS Law, and invite him to take the stage. Justice Chua, please.
Thank you, Dean. And since he has taken off his mask when he's speaking, I guess it's all right. Distinguished guests, ladies and gentlemen, good evening. Don't worry, I take this out only because as I grow older, it's harder to remember. Growing old is not much fun. Now, my colleague, Justice Abdullah, spoke of a business trust in a case involving Croesus Retail Trust. As you might guess, the name Croesus is of Greek origin. And yes, I turned to Google to find out how to pronounce it. Apparently, that's the way you pronounce it, Croesus. And I hope Google is correct. But also from Google, the story goes that King Croesus was immensely wealthy. And he's supposed to have derived his wealth from gold deposits belonging to King Midas. You know King Midas, the man with the golden touch. Anyway, that's probably why the founders of Croesus Retail Trust chose that name. But the story doesn't end there. The story of King Croesus, his reign ended when he was defeated by the king of Persia, King Cyrus. Happily, in Croesus Retail Trust case, that wasn't the unfortunate end. What brought the matter to the court was the fact that the Blackstone Group wanted to buy over Croesus Trust. And Justice Abdullah had to deal with it. And in fact, if you look at his judgment, at the end of his judgment, he said tongue-in-cheek that the case before him involved Croesus seeking to strike a deal with Cyrus. But back to the question of business trust. This is what Justice Abdullah said. He said that business trusts are essentially alternative vehicles for the channeling of commercial investment by unit holders through a joint enterprise. So the idea really is a vehicle to carry out business activities, financed wholly or in part by investors. Sounds like a corporate entity, right? Very much so. But Justice Abdullah also noted in his judgment that as the business trust, the Croesus Retail Trust was still at heart a trust. And yet, it was different from the traditional trust, because in that case, the unit holders did not have any equitable proprietary interest in the trust assets. So if you think about corporate structures, then the business trust, and what happened with Croesus Retail Trust, you can see immediately the different concepts, overlapping, tension between different concepts. And that was what then brought the case before Justice Abdullah. Hybrid structures, I think, do tend to give rise to issues, and business trusts are no different. And the area of restructuring is one of the areas where difficult issues arise. So like you, I look forward to this evening's lecture by Professor Hans Tjio. And I've known Hans since my much younger days as General Counsel of GIC. We've managed an occasional game of golf now and then. But whether on the course, off the course, when I meet with him, I never fail to take the opportunity to try and get his views on one legal issue or another. He always obliges me, and I don't want to pay for it. So it's with great delight that I'm here this evening. I'm very, very happy to have been asked to do this introduction. Hans is the C.J. Koh Professor and Director of the E.W. Barker Center for Law and Business at the Faculty of Law, National University of Singapore. He has taught at the faculty since 1990 and was the director for the Center for Commercial Law Studies and co-director of the Center for Banking and Finance Law. Hans has been a visiting professor at the other NTU, not the one in Singapore, but the National Taiwan University. He has also been a visiting professor at the Auckland and Shanghai's ECUPL, and was a visiting scholar at Stanford and Melbourne. Hans has published extensively including in international journals. He has written books as well. And he has held so many roles, different roles, with the MAS, the Ministry of Law, SGX, Securities Industry Council, and ACRA. Hans has also given public lectures at the law schools of Tsinghua and Zhejiang University. And in the EH-REIT case, which no doubt he will touch on later, he gave expert evidence to the Delaware Bankruptcy Court. I know that I have omitted to mention a good number of Hans' many accomplishments, and for that I apologize. And as you heard earlier, the C.J. Koh Professorship was established to enable U.S. law to engage distinguished legal experts to teach, to participate in research, and to help further Singapore in its regional and international roles. In that light, I have no doubt that Hans fits the bill in every possible way you can think of. Ladies and gentlemen, let's welcome Professor Hans Tjio to commence the lecture this evening.
Thank you very much, Shannon, Dean, and Justice Charlie Ming, for that wonderful introduction. He's characteristically modest because he says that he picks my brains on the golf course. We don't play that much because I can't say that I play golf in front of the Dean. But you'll find that actually he's the one that has provided almost all the case law in Singapore that will support the arguments that I try to make tonight. So again, as I said, he pretends that this is not his area, but it is, right? Before we begin, I would also like to introduce and thank Mr. Tan Suan Heng, who's better known as Mr. H.H. Tan. And he's the trustee of the generous fund that's been set up by Mr. C.J. Koh, Mr. and Mrs. C.J. Koh, and Mr. and Mrs. Ong Tiong Tat. All of them have been strong supporters of many healthcare and educational institutes in Singapore, including the NUS. Some of you would have had the opportunity to see exhibitions of the Char Kway Teow legacy, which is the book, I think, that the Dean was talking about. And this is a legacy, it's something that Mr. Tan has founded. And the exhibition tells us about how both Mr. C.J. Koh and Mr. Ong Tiong Tat came together over a plate of Char Kway Teow at the Zion Road Hawker Center, if I got it right. And they came up with the idea that we had to give dangerously, or another way of putting it, which has a slightly more religious undertone, which is to donate as much as you can until it hurts. And I think they have done that quite clearly over the last 20 to 25 years. So, good evening, ladies and gentlemen. It's wonderful, as the Dean says, to see so many of you here today. I should also actually say that I'd like to see so many familiar faces or familiar masks here, but I've not actually told a joke in 32 years of teaching, and I think I better not start now. It never works for me. In any case, we can all take them off in 5 days' time, so perhaps we can take them off when we have the reception after this, right? But I'm not sure how I'm actually going to do a presentation like this in the next few years, because this presentation is the result of COVID in a way. I mean, COVID-19 has unfortunately taken away quite a few lives, and it's created problems for many of us. But in terms of research, it's actually helped a lot of us, because for 2 years we couldn't go anywhere, and we were stuck in our rooms. And so a lot of research was done. And this presentation, in a sense, was a result of that, of those 2 years. So if Mr. Tan wants me to do something like this next year, I'm not sure where it's going to work, because I haven't actually done that much research this summer, where all the traveling has started, people have started visiting, and they want to have in-person meetings. So I may not have a story next year. This year, however, I hope to have a slightly interesting story, and it's about REITs and how they came about 20 years ago. So REITs began in Singapore in 2002 as collective investment schemes. Those of you who are in corporate practice would know that collective investment schemes under the Securities and Futures Act are really there to govern unit trusts and mutual funds. But the first REITs that came into Singapore were structured that way. It was effectively a form of unit trusts, but where the underlying property was real estate rather than securities. As you know, with unit trust, there's a separate trustee and manager. And this was a form of securitization, probably the first forms of securitization in Singapore involving real estate. What then happened 2 years later was the Business Trust Act was enacted, and this was for other forms of securitization involving infrastructural trusts, involving shipping companies, which wanted to divest themselves of certain ships, and these formed the basis for some of these business trusts. Some foreign property entities also used the business trust as the structure under the BTA. Now, what you'll find is that on the Singapore Exchange, almost all the REITs, where the underlying securitized property is real estate, have used the collective investment scheme, I'll call it the CIS form, rather than the business trust, the BT form. And the reason for this is tax transparency that is given to the CIS REIT. What is tax transparency? Well, many of you know tax, and I see some of you here who specialize in tax, right? But with tax transparency, that means that there's no entity or corporate level taxation. And so investors are taxed at their own level. What we have are institutional investors, therefore then taxed at their marginal tax rates. But individual investors in Singapore, as well as overseas, are not taxed at all. Because in Budget Statement 2004, it was said that all the income that's generated by the REIT would flow through to them untaxed, and it would also not be taxed at their level. So the first REIT in Singapore was the Capital Mall Trust that involved Tampines Mall, the rental income generated by Tampines Mall. I'm told it's a very good mall in Tampines. That flowed through to individual investors without any tax. And this has made REITs one of the most successful financial instruments that are listed on the Singapore Exchange. So much so that it is said that sometimes between 12 to 15% of the market capitalization of this SGX are made up of REITs and business trusts. The trading volume on certain days is even higher than that. Right? So it's become, in that sense, very successful. However, and this is a different story altogether, but some of us have looked at, the bond market has had difficulties for 10 years now. Right? It started with commodity prices weakening, first in 2012 and then in 2015. And so we've had issues in the bond market. And this then spilled over to trusts that had borrowed money, and bondholders had to have some of their rights reorganized. And so from around 2017, we've also seen commercial trusts needing to be restructured. Now in Singapore, most restructuring takes the form of schemes of arrangement. The problem for trusts, which is the issue that we'll be discussing today, is that it isn't a company. Right? So how is it going to be restructured under Section 210 of the Companies Act, and which is now Section 64 of EH-REIT, which, when it's not a company, right? And I foresee that there will be more problems going forward, and many people have foreseen this, because with interest rates going up, you're going to see bond prices fall, and there's going to be even more restructuring of bonds required over the next few years. The case, this is just the overview of what we're going to be talking about. The case that Justice Charlie Ming mentioned, there was a decision of Justice Aided Abdullah, was the Re-Croetius case. And I also had to look up how, because the very first time I referred to it as Re-Croetius, right? Nobody knew what it meant. Re-Croetius drew parallels with the scheme of arrangement for companies. So it drew a parallel with Section 210 of the Companies Act. So it appears as if you could restructure it that way, right? But this was questioned subsequently in a scheme meeting. So there wasn't a decision in Soil Bill, because Justice Charlie Ming also mentioned that he checked and Soil Bill isn't reported. But that's because there was a scheme meeting. And you know that with schemes, there's always a meeting to decide on whether the classes have been properly characterized, and then subsequently a meeting to sanction the scheme. So that was questioned subsequently, what the basis of scheme restructuring was in Singapore. What we do know is that Rules of Court Order 80, Rule 2, creates an inherent supervisory jurisdiction for the court over trusts, right? So for things like variation of trusts, where we don't have a separate Variation of Trust Act in Singapore, unlike the UK, you could go under this provision to vary the terms of the trust. But it has been said in Australia and New Zealand that that jurisdiction, that inherent jurisdiction, does not extend to the liquidation of a trust. And so this is an issue that the Australian Law Reform Commission is actually currently looking at since December. They've set out a consultation paper as to how you can actually try and solve this problem at the level of the trust. what we have seen 3 years ago, the High Court of Australia spent a lot of time with a huge intellectual effort trying to wind up a trustee in a case of a business trust rather than a trust. So in Carter Holt Harvey Wood Products in Australia, the High Court of Australia, the highest court of Australia, said that there was no trust as such to wind up because, as we know, the trust isn't a separate legal entity. You've only got your trustee separately, sometimes it's a trustee manager in the case of a business trust where they merge. And you've also got your beneficiaries, right? You've got these parties, but there's no trust as such to wind up. Now, this case was even more complex than that because this involved a business trust giving floating security over trust assets. So they don't have the floating charge anymore in Australia, but they still have a concept of floating security. And we're talking here about two concepts which aren't firmly grounded in some kind of entity or property reasoning. So we know that the trust isn't the company, right? We will see later on that it has certain attributes that make it look a bit like a company. At the same time, you've got a floating charge here that's always been a problem for us in terms of determining its nature, right? So much so that Professor Good is the one who came up with this idea of the floating charge working only because it exists over a notional fund, right? All of you know that the floating charge basically doesn't latch onto anything until it crystallizes. But it is very hard to visualize this as present property because present property must exist now. So he creates this idea of a notional fund which exists regardless of what is inside that fund, right? So with the property of a company, the undertaking, the stock and trade, that changes all the time. But it doesn't matter because the floating charge has latched onto this notional fund. That, I think, will be the gist of the argument I'll try to make today, right? But the reason why I try to make that argument, because Carter Holt Harvey showed us how difficult it was to wind up trustees as opposed to the underlying trust. The only way we'll see that the trust creditors can reach trust assets, and I'll show you a diagram after this, is not directly. It's not like a company where the creditors of a company have a direct claim to the company's assets, right? In the case of a trust, we will see the trustees are the ones who have some links or relationship with the trust assets because they're the legal owners of it, right? But they have a right of indemnity for any payments they have made on behalf of the trust, and they also have a right of exoneration where they can be exonerated for certain claims against them, and they can claim this sum from the trust fund. But trust creditors can only reach this trust fund from being subrogated. It's an insurance idea, right? You subrogate yourself because you provided the funds, and you put yourself in the position of the trustee, and then you use that right of indemnity and the right of exoneration to reach those trust assets. I will go back and forth between this slide and the next one because I think that a diagram helps in explaining the difference between the right of exoneration and the right of indemnity. So let's talk about the right of exoneration first. Just visualize a trust creditor, and this may be a bank, it may be bondholders, and they lend $100 million to the trust. But the loan contract is made with the trustee. That's the way it is. There is no trust entity, unlike a company. But the money that is lent to the trustee is not meant for the trustee. It goes immediately into a trust fund. And that trust fund is beneficially owned by the beneficiaries and unit holders, right? And this has always been the problem for trusts. It does create co-ownership, but it creates co-ownership at a horizontal level, where the trustee owns the legal title and the beneficiaries own the equitable title, right? The problem with this is that the trust creditor only has a claim against the trustee, and the only way it can reach the trust fund is for it to be subrogated to the trustee's right of exoneration from the trust fund, right? So the trustee doesn't have to pay back the $100 million itself. It can be exonerated by asking the trust fund to pay the trust creditors. I think that's fine and that's well. I think a lot of us have accepted this. The problem is there's also a right of indemnity that the Australian High Court dealt with. And there were 7 judges, there were 3 different judgments, but only one judge was bold enough to say that where the right of indemnity is concerned, let's go back to that one. So with the right of exoneration, only the trust creditors can claim that because that's the money, the $100 million that they lend. But the right of indemnity is different. that one, the trustees' own creditors can share in that sum of money. Now, Professor Michael Bridge was the one who asked me this question. He said, what's the difference between the two? And so I think we decided to visualize it this way. Say that's also a fee of $10 million that has to be paid for this loan to be created, right? So that fee had to be paid out of the trustee's personal estate, $10 million first. And that then gives rise to a right of indemnity on the part of the trustee, right? Its own separate personal estate has a right to claim that $10 million from the trust fund because it originally paid that sum out first. But the problem is that we know in trust law, there's always going to be some kind of mixing that goes on because the two separate estates aren't as clear as you have in the case of a company, right? Where whoever controls or manages the company obviously has its own estate, and that's different from the company's estate. We've always had difficulties in practice in distinguishing the trust fund from the trustee's own monies. We know about mixing. You've studied in tracing. There's always this problem with mixing. And that then leads to legal problems because there's also a legal problem that arises from mixing as to whose money comes out of these accounts first and so on. And I think that's why the Australian judges did not make it quite clear that it should really be the own creditors of the trustee that claims from that right of indemnity. And I'm not sure the trust creditors, right, if you can identify that the sums for the fees paid, the $10 million, came from this separate personal estate, I'm not sure why the trust creditors should have a claim against that. But it does show you that there are difficulties and uncertainties, and there will be a day moving forward where we'll have to distinguish this right of indemnity and right of exoneration a bit more. In fact, I would say that until the Australian High Court decision, most people referred to it generically as the right of indemnity only. We didn't see the difference between the two, right? But there are also further problems with trying to wind up the whole thing at the trustee level. And this is that, you know, in the case of a company, for example, you know that there are preferential unsecured creditors and there are ways of the priorities there, right? It's harder to visualize how this works if you're going to wind it up at this level instead of seeing this entire thing as a separate entity. But in Carter Holt Harvey, the High Court of Australia was willing to apply the unsecured preferential creditor provisions in their Companies Act to the unsecureds here. However, they left unclear the issue of how non-preferential unsecured creditors ranked with each other, right? So there's always this problem with trust. It's less certain, certainly, than in the case of a company. So what's the solution? And this is what I call it the Singapore solution, but we'll see that it's only a partial solution, perhaps. I'll tie it up with some judgments that Justice Chua Lee Meng has come up with recently, and then also tie up with the EH-REIT case that Justice Chua Lee Meng mentioned to say that US provided some assistance in coming up with the final solution. So restructuring as opposed to winding up, it's even more difficult at the trustee level. If we look back at this, yes, you can talk about debts being restructured at this level, but when you talk about restructuring, right, you've also got the beneficiary interests, the unit holders, and so on, and their claims are at this level, right? So it would be ideal if we could sort of merge the trustee and the trust fund into one and have everything dealt with at the same level, at the same entity level. The further problem with US and Singapore business trusts, and this would be the result of some of the drafting that has come out of some of you in the law firms that have done REITs here, is that it specifically said that in the case of Singapore business trusts, the trust creditors have no recourse to the trustee, but only to the trust fund. So there will be some agreement that is made either between the trust creditor and the trustee. Perhaps there's also something in the trust deed here that says that the trust creditors will have no recourse to the trustee, even though the contract is made with the trustee, but the only recourse is against the trust fund. Now, this may work, but we have to be careful because this is imposing a burden on a third party, right? Assuming that the trust fund is, in fact, an entity, you are still trying to impose a burden on a third party. Worse, if the trust fund isn't another entity, you are imposing a burden on beneficiaries who may not have agreed to it, right? So this becomes a problem if the trust fund refuses to pay or cannot fully pay up as well, right? Because even if it wants to pay, it might just be that there's not enough money in the trust fund, right? So 2002, the first REIT started in Singapore. They were quite successful. But with the global financial crisis, I think the first series of problems with REITs occurred in Singapore. But this did not involve insolvency, restructuring of REITs. I think with the first issues, it was all about merging them, privatizing them, allowing takeovers of them. And so actually, it was the SIC that first dealt with this issue about what to do with REITs and whether we should use schemes of arrangement to try and restructure these REITs. And again, these are non-insolvency. This is non-insolvency restructuring, right? And what the SIC practice statement said was that the REITs and business trusts could be merged or privatized using trust schemes analogous to those in Section 210 of the Companies Act, right? What do you need to do? One, you have to comply with the trust deed. So the trust deed must be consistent with what you're trying to do. And secondly, you need to obtain court approval under Order 80, Rule 2, i.e., the provision which gives inherent supervisory jurisdiction to the court over trusts, right? And the reason why I think we needed to give some substantive basis for this is that if winding up and restructuring is simply a contractual matter, you are always going to be worried that somebody's going to challenge it in the near future, right? And here I do recognize Gary. I think he writes a very good commentary to a book that Professors Wan Bai Yi and Umakan Varatil have put together on takeovers and mergers. And in that chapter that you comment on, you make the point that although Section 210 is problematic in the sense that you go to court to get approval for the class meetings, and then you need to have court sanctioning it, it also gives you peace of mind, because once the court sanctions it, you know that you're quite safe and that you're not going to be ambushed, I guess, by some creditors or unit holders in the future who feel that they have been unfairly treated, their rights have been extinguished, or they've been oppressed in any way. But again, this was an SIC statement. When the things first started coming alive, right? And this was with the first trust that needed some restructuring. This was Rickman's Maritime. It actually failed because I guess people still weren't sure how we were going to go about and do this restructuring. Rickman's Maritime bondholders were very unhappy with the deal that had been offered to them because other companies that were in difficulties on the SGX at that time, with the bonds that were listed on the SGX wholesale market. So a lot of these bonds with these financial institutions, with these business trusts, are all basically listed on the wholesale market, right, in tranches of 250,000. For the first few restructurings, it looked as if there was going to be full redemption of their notes, whereas that wasn't the case with Rickman's Maritime. And so the bondholders refused to agree to a restructuring. And so in April 2017, Rickman's Maritime was wound up. But not long after that, the first restructuring of a business trust actually occurred, and this is the Cretius case, where Justice Aided Abdullah relied on the SIC practice statement in 2008 and approved a scheme of arrangement of a foreign property-based business trust. So again, as I said, local property REITs would use the CIS regime because of the tax advantages, but some foreign property REITs might not be able to do it that way. And so they structured it as a business trust, where unfortunately they would be taxed at the entity level, right? But he restructured it. And he said it was apparent that the proposed orders largely paralleled that in an application for a scheme of arrangement under Section 210 of the Companies Act. As Justice Chua Lee Ming said, Justice Aided Abdullah noticed that the trust was still different from the company, but he tried to draw parallels with the company in order to restructure the business trust. 4 years later, however, in a soil bill, which, again, this was the scheme meeting, it wasn't a decision of the court. This was a privatization scheme of a standalone CIS REIT. So this is a REIT now, not a business trust, right? But I'm going to make the argument that they're not really different in substance in the next few slides. And again, this involved foreign assets, Australian assets, but it was structured as a CIS REIT. And here, Justice Vinod Kumaraswamy, however, expressed great interest in the separate question as to where the legal basis of a REIT trust scheme can be found. So he was worried because he was mindful of the fact that there were doubts about the basis on which the rights of unit holders can be expropriated, even under a trust scheme. So if you are just sort of doing things in a way which doesn't lead to rights being crammed down, for example, right, and rights being expropriated, perhaps you don't have to worry so much about the subsequent challenges. But if there are going to be serious issues of the rights, affecting the rights of bondholders, then you have to try and make sure that the way you do it, especially when so much money is involved, is above scrutiny. Okay? Now, neither of these cases was about insolvency restructuring, but Professor Wee Singh has also pointed out that member schemes and creditor schemes are quite different. However, many textbooks today still sort of seamlessly move between member schemes and creditor schemes, and it's also the case that judges don't always differentiate the two. Right? But it's in the US, or with the assistance of the US, that we had our first insolvency restructuring, a creditor scheme, and this involved a CIS REIT. So Eagle Hospitality Real Estate Trust, we'll just call it EH-REIT from now, right? Was a CIS scheme involving US properties, and this was stapled to an inactive business trust. So this business trust was never activated. It was only the REIT that was in existence. The EH Business Trust, I'll call it EHBT, was established primarily as the master lessee of last resort if the REIT, the CIS REIT, was unable to appoint any other master lessee, right? Or if there were no other suitable master lessees. So the business trust was really set up as a backup to lease these properties in the US, these hotels in the US. And it was a pretty famous REIT because amongst the properties were the ship, I think the Queen Mary, that was docked in Los Angeles and that had been turned into a hotel. But it was also bleeding the business dry because that was very expensive to upkeep. And once COVID hit, right, the hospitality sector was really, really badly hit. Problems arose, right? Actually, problems arose almost immediately because there were problems with the prospectus disclosure and also continuing disclosure after that. But our concern is with the inability of the REIT to generate enough funds to pay dividends to its unit holders. So, with the onset of COVID-19, the EH-REIT, the share price was suspended, right, in March 2020, and a dividend had never been paid to the unit holders. There was also a gearing ratio of 45% that was then raised to 50%. This goes back and forth, right? Now, I'll just say something about gearing ratios. So if you choose to be a CIS REIT, you're going to have gearing ratios applied to you. Whereas if you choose to be a business trust, there aren't these gearing ratios. And again, this goes back to the fact that the CIS was meant for unit trusts and mutual funds, and therefore we needed to control how much money they could borrow. If they had chosen to be a business trust, those restrictions weren't there. Right? And I should say something else about the EH business trust that never came into existence. Another reason for that to be a fallback position was that REITs can't go into development property very much. They actually have to own already built property, right? They're not really meant for developing property because that would be more like running an underlying business. So if you wanted to do it that way, and more than 25% of the assets of your fund was going to be developmental property, you would have then had to use a business trust, right? So that's why there was this other business trust component, but that was not activated, right? But problems carried on with the EH-REIT. In December 2020, the REIT manager was removed by the REIT trustee on MAS's instruction. So again, this was a CIS REIT. Therefore, there's a separate manager and a separate trustee. But the manager was removed, right? And DBS trustee was then empowered a month later to take any action it deemed necessary for the management and administration of EH-REIT and its business. So in a way, in practical terms, it had sort of merged the trustee and the manager into one, which makes it more like the structure that the business trust has when you have a merged business trustee and manager as one. Immediately, DBS trustee joined the Chapter 11 cases that had already been commenced in the US, but these were with respect to the SPV affiliates, the companies lower down in the group, which had already begun in the United States. But immediately after that, Chapter 11 proceedings in respect of EH-REIT itself commenced in the US Bankruptcy Court in the District of Delaware. I guess the idea is that it's always easier to preserve value, and it's much less untidy if you can restructure everything at the highest level possible. Right? However, the basis of the court assuming jurisdiction under Chapter 11 was challenged by the Bank of America on the basis that EH-REIT was only a collective investment scheme, a CIS, and not a business trust registered under the Singapore Business Trust Act, right? Yeah, and my opponent in that case, the expert, was Professor Kellery Loy, who's sitting there. So if you've got questions on this, you can ask him about that as well. So Bank of America really wanted the restructuring or winding up, if that was to occur, to happen at the lower affiliate levels, right? Perhaps they thought they had more control of the restructuring at that level. But Chapter 11 provides that a person may be a debtor, only a person may be a debtor, but that person can include a corporation, and in turn, a corporation includes a business trust, right? So it wasn't a problem if this had been in America and it had been a business trust under the Delaware Acts. It would clearly be restructurable, if that's the right word, right? But Chief Judge Sonchi, who has since retired from the Delaware courts and in fact is now a judge on our Singapore International Commercial Court, he held that EH-REIT was a business trust eligible to file for Chapter 11 bankruptcy in the US, as the law applicable to the test of whether it was a business trust was not US law, but Singapore law, right? It was not federal bankruptcy law or common law, right? There's always this debate about whether there's really a federal common law in the US, but it didn't matter, right? It was Singapore law that governed. And as we have seen, in Singapore, REITs can choose to be regulated as a CIS or as a BT. The choice is up to the REIT. The basis for Chief Judge Sonchi saying what he did was this famous US Supreme Court decision in Butner versus the United States in 1979, which led to Thomas Jackson's book on the theory in bankruptcy law that rights outside of insolvency should be respected in insolvency as well. And the reason for this is that insolvency and the bankruptcy process should not alter pre-bankruptcy entitlements, as that would give people the incentive to trigger off the insolvency process to reorder their rights. So if you believe that things which are going concerns should be preserved as long as possible and you give it a chance, you shouldn't sort of reverse or change laws that are applicable in insolvency, because then that would push people to use the insolvency processes more quickly, right? This is not, we cannot be too fundamentalist about this, but that is certainly an idea that underlies bankruptcy law. So, while they were not business trusts under the Business Trust Act, Chief Justice Sonchi thought that under Singapore law, they were sufficiently a business trust, right, under Singapore law, and they could be restructured as such, because that was, in fact, what the High Court had, the order of the High Court had made in January 2021, when they told DBS trustee to take over all the functions and to report back every few months as to what was going on, right? And also he said, the trust deed makes it very clear that the acts taken by the REIT trustee in its capacity as trustee of EH-REIT bind EH-REIT and not the trustee, right? So it is giving some legal form or ring fencing to the EH-REIT, which is otherwise just a word that would, or label that captures separately a trustee and the beneficiary, right? So we are giving some life in that sense, some kind of notional entity status in Professor Good's terminology, so that claims can be made against it. Because if claims can't be made against it, you're going to be left with a black hole of liability, because the creditors won't be able to claim against the trustee, because the trustees have disclaimed all liability, and they can't claim against the trust fund, because the trust fund is a stranger to this, right, and you're imposing a burden on the trust fund, and in any case, there is no trust fund as a separate entity. So does this mean, or does this have to mean, that REITs and business trusts have separate legal personality? Chief Judge Sonchi said that EH-REIT did not, in fact, need legal personhood for it to be restructured. So it's not strictly necessary, because as we'll see later on when we talk about some of the ideas called asset partitioning, which is in the next few slides, you don't actually need an entity for this, right? There are ways of doing this contractually sometimes, and there are other ways of doing it. But it does help matters, and it does focus the mind if there is, in fact, some kind of legal personhood attached to it. So he thought that if legal personality were, in fact, required for the business trust, it had some attributes of legal personhood, which are sufficient to support a finding that it is a business trust. So what are these attributes of legal personhood? And here I'm going to take you back 22 years now, by probably what's been the most influential company law article in the last 50 years. And these were by two professors, Hansman and Crackman, in the Yale Law Journal of the 2000, where they came up with the idea of affirmative asset partitioning. Now, I'm going to simplify it a bit, and it's not really strictly accurate what they're saying, but I guess one way of looking at it is that separate legal personality, what we learned in company law, right, many, many years ago for some of us, we talked about it being able to sue and sue in its own name. There's perpetual succession. Those things aren't really that important, right? You find that in Section 19(5) of the Companies Act, but so what? What they say is most important about the corporate form or any business form that partitions assets is that it allows creditors to have direct claims against a segregated fund with whom those creditors contract, right? And that this fund itself must be capable of being wound up and restructured. Now, this is actually the opposite of limited liability. For many years, when we studied company law, we thought limited liability was an amazing thing in the company's context. But we know that limited liability can be given to partnerships, right? It has nothing to do with the company. Your limited partnership has limited liability for the general partner, and your limited liability partnership has limited liability for every partner out there. So it has very little to do with the company structure, and in fact, limited liability is quite easily contracted for. The reverse is harder to contract, and that's where company law was necessary to create this affirmative asset partitioning. And what it really does, and I'm not sure I can represented it that carefully, is that when I said earlier that the trust segregates property into two at the horizontal level, right? You've got a legal owner and a beneficiary, they're co-owners. But the company basically bifurcates property in a vertical level, right? Such that whatever was the original property is now owned by the company, and now we have created a new property, the share, which is owned by the shareholders, and that happens at the vertical level. So it creates a far more efficient system for doing business. And we'll see that hopefully in the next few slides as well. But this means that creditor claims are limited to the part of the bifurcated structure that it lends to, right? So creditors of shareholders can only claim against the shareholders. Creditors of the company can only claim against the company. But that means that the company's fund has been set aside for the creditors of the company, and you don't have to make any reference to the shareholders. We saw earlier in the earlier slides of the diagram is that there's always a problem in the case of a trust because the beneficiaries actually own the equitable interest in the trust, right? And you need to get their approval if you're going to subordinate their interests. The entity in Singapore that shows the beauty of this bifurcated structure is the Singapore Variable Capital Company, right? So not only does this separate bifurcate property at this level, so the shareholders and the company are different, but within the company itself, different creditors have claims to different parts of the company, right? The company now has different funds that it owns, and each sub-fund has its own creditors, right? So that's what Section 29 does. It expressly allows for segregation between sub-funds through the VCC's cellular structure, and orders can be made against the property of each sub-fund, which can be wound up as if it were a separate legal person. So it's great. And I think there was an article that Ming Sing sent to me last week, right, in the Financial Times. About 590 SVCCs have been set up in Singapore. It's become quite successful. At the same time, creditor rights are limited to the part of the fund they lend to, but unit holder rights are also reduced, right? Because we said earlier, and I think it's something that Justice Aida Abdullah noted and Cretius, is that in these things, we are making the unit holder, i.e. who are the beneficiaries, have rights which don't seem to accord with what we thought beneficial rights should be, right? Because some of you remember this phrase, the beneficiary principle, right? Which meant that beneficiaries must own the underlying trust assets. But look at this clause that comes from the Singapore Property Trust, which was actually the first property trust that was attempted in Singapore in 2001. It failed because it didn't get all the tax relief that it hoped for. And every single REIT since then has replicated this provision. And this says that the trust deed sets out the rights of the unit holder. Each unit represents an undivided interest in the SPT, the Singapore Property Trust, which again I say is not a separate entity, it's just an idea, right, that is slowly being created or coded into a separate entity. A unit holder has no equitable or proprietary interest in the underlying assets of the SPT. So the beneficiary principle isn't satisfied in the traditional way, right? It is not entitled to the transfer of any asset or any estate or interest in or any asset of the SPT. So they have no direct claim to the trust assets. Instead, a unit holder's right is limited to the right to require due administration of the SPT in accordance with the provisions of the trust deed, including by suit against the trustee or the manager. So that last line shows that the trustee and manager are still separate entities, and they are not the SPT. So the SPT is another thing that's being created as an organizing idea, right? To make it easier, I guess, to sell the units to unit holders, but it is not formally a separate entity on its own. So we are replicating the company structure here, because what the lawyers who drafted this were trying to do is to try and follow what happens in the case of a bifurcated company structure, where shareholders only have rights in the company, but not in the company's assets, right? Larissa Katz calls this rights in a procedure, right? So that's what shareholders actually have. They have rights in a procedure. What rights do you have? A right to vote, right? A right in some situations to call a meeting, and so on, right? At the same time, we also see in some of the loan documents where the trustee saying that they guarantee repayment, but only from the trust fund. And this then goes against stuff that Professor Dora Neo teaches, right? When we look at credit and security, a guarantee is very dangerous for the guarantor, right? Or the surety, because of the obligations you assume. But here, the guarantor, so-called, is saying that I'm not assuming personal obligations on this, but you can only look to the trust fund. So all this is how is the work of lawyers, right? Some kind of private ordering going on. But how is all this recognized in the Companies Act, right? Which today we see largely dealing with incorporated registered companies only. Because we come back to the story. Yes, you can do your private ordering and all that, but there's always a risk it won't work. And it's always better to have some kind of sanction or recognition in the Corporate or Companies Acts. So we're going to look at this structure to see how things have been changed somewhat, and then to see how the Companies Act has accepted this, right? Gosh, okay, I better go a bit faster. I'm not sure how time flies so quickly when you're having fun, right? So we've seen now about coding, right? And this is Catherine Pistor's famous book on coding capital. I would like to say that I got my PhD students to read this, but unfortunately they read this book before I read it, right? So very often my PhD students teach me more than I teach them, right? But her argument is basically that lawyers have played a big part in coding capital. And this started with land in the Wild West in the US, right? Where they were taken away from Native Americans because it was terra nullius, because the Indians owned nothing. And all they needed to do was, put a few fences, some stakes in the ground, and then lo and behold, they own property. Today, of course, non-fungible tokens, right, are something that I think lawyers have helped create. And it's very clear that the word non-fungible is used because it addresses a problem from Re-London Wine, which says that fungibility defeats proprietary interest. And so we call it a non-fungible token so that perhaps it'll be more accepted as property. But coding is not just of property. Here we have coded the trust as a company. What we have done is that we have moved trust creditors' claims against the trustee against a trust fund, right? It's been substituted, in a sense, directly against the trust fund. At the same time, beneficiaries and unit holders no longer have claims against the trust fund. They have no equitable interest in the trust assets. Instead, their rights have been shifted, and they have rights to due administration of this entity now, which is this notional entity, which is slowly being given more and more legal recognition. At the same time, because the trustee is no longer the legal owner of the property, you can see the trustee more as a director of the company, a manager of the company now, and this person clearly has its own estate, right? So there's nothing to worry about. We can remove the question mark over its separate personal estate. He's got its own the trustee has its own creditors, and it's got its own fund, and things become clearer the way it is in a company. But how does this happen? And the argument now is that we still need to get this into the Companies Act to give it greater support and recognition. This is consistent with what Professors Zhang Tai-Su and John Morley, who have now recently, in the most recent Yale Law Journal article, argued that the modern business corporation could really only come about through strong state recognition and sanction. So we've always talked about private ordering, and some of us still think that the Companies Act is quite contractarian in nature, right? There are a lot of contractual provisions there that you can contract out of. But there are also a lot of mandatory provisions in there. And those mandatory provisions are there and help, and in fact, you need to fall back on them when there are serious problems with the contractual structure that you have created. So I say that in extremis, you find that you do need to go back to the Act and the courts, right, to legitimate what you've done. We know that all entities, the point is that the Companies Act does have mandatory rules, and these are important to reify the company in its present form, so that people have more confidence in it, right? Now, this asset partitioning story that I mentioned earlier from Hansman and Crackman 20 years ago was really a property argument about the efficiency created by this bifurcated structure, the company, right? It's far more efficient. But at the same time they were coming up with that idea, in the East Coast of America, two other professors were also coming up with their information cost story about properties and entities as well, right? And this was Merrill and Smith, and their argument is that property as a thing is about exclusivity, and this correlated with information costs, right? But where information costs are low, parties should be given autonomy to do whatever they want. So the two-party contracting is the clearest example of having as much freedom as you want and coming up with the terms that you want. But as what you do affect more and more people, right, and you're trying to have your rights extend to third parties and so on, then you are creating intermediate rights now which are between contract and property. And the strategy there to have this to work is first disclosure, that you must disclose this to third parties before it works. And then, if it becomes even more widely used, right, it has to become mandatory, right? And then it becomes even more used and more, and people will need to get familiar with it. You create an entity that has separate legal personality, which is the corporate structure, right? So that's the story that they had. But Tai-Su and Morley says that those mandatory rules came about less through custom and law merchant. So there was this theory once, right, that the law merchant could do a lot of things. But their story is that there was little demand earlier on for mandatory rules, but more and more required, and the state had to intervene as uniformity was desired, right? Because the story that we see from the UK, and I think Tai-Su and Morley's story, I don't think it fits the UK experience perfectly. It fits the US experience more. But I think there is something there. Because we know that the UK Joint Stock Companies Acts in the mid-1800s, I think the first started in 1844, Joint Stock Companies Act. This didn't actually do very much, didn't change things very much. And many of the initial companies that were registered were in fact co-partnerships. And this has most recently been recognized by Justice Chua Li-Ming in this case called Song Jianbo, right, last year. Song Jianbo, missold many preference shares to Chinese investors. And they were then redeemed maybe a year later at a huge loss because they said that the market had turned against these investments. And so we needed to redeem these things at a huge loss. Song was sued by these investors for misrepresentation. The argument that was raised by Song was that you can't sue me unless you rescind the contract for the purchase of the shares. Because there was this old case in the UK called Holsworth and the City of Glasgow Bank, which says that a subscriber of shares from the bank had to rescind the share purchase contract before damages could be obtained from the bank, right? And if there are any bars to rescission, like winding up, that stops you from rescinding the contract. But Justice Chua Li-Ming observed that that case involved a bank that was a co-partnership, because in the mid-1800s, the 19th century, many of these things were registered as companies, but they were actually banks that asked investors to put money in, and these people invested as partners, right? And they received dividends. And then when things went wrong, they tried to say, hey, I want some of my money back. But the court said that you cannot approbate and reprobate at the same time, right? You cannot both be a shareholder and not a shareholder. Or rather, you cannot be a partner and not a partner at the same time. But Justice Charlie Ming observed that modern companies are not like that, right? Almost all the companies today are limited companies, and so this restriction in the Holdsworth case did not apply, and Song could not use that defense. And this was also helped because there were many changes to the UK Companies Acts. It was first the Joint Stock Companies Act, then Joint Stock, and then became the UK Companies Act, right? But still, they were only slowly convincing people to use the corporate form and to use the real corporate form as opposed to being partnerships that were registered as companies, right? And it took time to create the modern company in the UK. The US story, however, is different. That from the very beginning, it was guided by state charters. I guess they didn't have the number of sophisticated lawyers, and I think there's another article that's been written about this, where they needed the state legislatures to create corporations acts to encourage business to grow, right? And I think this is a story that David Kershaw also has made as to why, actually, although we think the US is more flexible, a lot of it was created by the state, whereas in the UK, many things were actually created by the private sector, right? And that also explains why today, UK partnerships under their Partnerships Act and UK business trusts under their Business Trust Act, in places like Delaware, for example, all clearly state that these are separate legal entities, right? So all US partnerships and all US trusts, business trusts, are separate legal entities. But it's only a default rule. So it's not a mandatory rule in saying that they must be that. It's a default rule that's a starting position, but you can contract out of it. However, we know that Commonwealth partnerships and trusts have not gone down that way, right? But what we have observed is that they also have some asset partitioning functions that give creditors who lend to them some priority over claimants, even if they cannot be sued or sue in their own names. So we know the partnership is not a separate entity. But there was always something called the jingle rule, which doesn't apply fully now, but it used to be a jingle, came out of South Africa, actually, some people say. I don't know the song and how the tune, but it goes like that, the words. Partnership estate to partnership creditors, private estate to private creditors, anything left over from either go to the other, right? So even with partners and partnerships, there was always this ability to try and find some kind of asset partitioning that goes on. And Hansman and Crackman says that they've always had weak entity shielding, right? So there's something there. That's fine, and I'm going to show you another case later where Justice Charlie Ming has confirmed that this is possible in Singapore. But in the UK Privy Council in Reinvestec, which heard an appeal from Jersey, said that the default position for trusts in the UK is still that you must sue the trustee, and there's no such trust as such, right? But we've seen that it's almost always the case with business trusts in Singapore and the US, that the terms of the trust, as well as the loan documentation, they make it clear that the trustee is only committing the trust fund to the agreement and excluding itself when it borrows on behalf of the trust. So it has to work, because if it doesn't work, there's a black hole, right? So how did this get resolved? I think we have made it even clearer in Singapore now, but I would say that if you go back to the 19th century, you find that the Victorian legislatures knew what they were doing when they crafted the companies' legislation the way they did. Partnerships and trusts were actually considered unregistered companies under the legislation, and I think this continues to allow them to be liquidated, although not voluntarily. It has to be an involuntary liquidation, and it can also be restructured, as Justice Aided Abdullah said, is through analogies, right, since it's not a full separate legal entity. And the provisions that provide this were formerly Sections 251 of the Companies Act and now Section 245 of EH-REIT. And these are the provisions that a lot of people think apply to foreign companies. But it actually says it applies to foreign companies and any partnership and association, right? This was recently recognized by Justice Charlie Ming in Tan Hua San and Tan Hua Tai, where he said that a partnership, and if I'm not wrong, this was a general partnership, right, could be wound up as an unregistered company, right? He also discussed that a receiver could be appointed to preserve the partnership assets and pay its debts while the court takes the usual partnership accounts and supervises the dissolution. So even receivership itself can actually partition assets, because even this order that Justice Chua makes shows that we are treating the partnership as some kind of entity on its own, aside from the partners. Right? And in any case, even today, we know that the company, the registered company, is just an artificial construct. Right? It's only in the US where they think that it's almost like a human being. For the rest of us, really, it's still an artificial construct. Our Court of Appeal recognized this in Townsend Honoree. The UK Supreme Court recognized this in Bilter and Nazir, right? And we've also seen that until Salomon and Salomon in 1897, despite all that earlier Victorian legislation, consolidating acts, those acts that Holsworth came under, the company was regarded as the associated members rather than the legal entity. And this was said by the late Professor Len Seeley. Right? More recently, you have Professor John Armour saying that the company was always them rather than it, right, in the 19th century. So early legislatures provided for the winding up of such entities because they knew that there would be regulatory arbitrage, right, and they feared that. And in fact, if you look at the early Victorian era corporate legislation, half the provisions were all on winding up or liquidation, right? It showed you their concern with fraud and insolvency with respect to these business entities, whether they were incorporated companies or whether they were co-partnerships, right? Unfortunately, much of how the provisions on winding up unregistered companies came about, they've been forgotten. And many of people think of these things as just applying to foreign companies, right? So there are textbooks that you read would talk about unregistered companies being foreign companies only. And it's also further confused because the UK textbooks will talk about the UK Companies Act provisions that deal with unregistered company. But this is not about the winding up of unregistered companies, which is in their Insolvency Act of 1986, right? This is in their Companies Act, and this is about the regulation of foreign businesses that try to set up businesses in the UK and have an advantage because they don't have to incorporate in the UK. And these provisions are about that. They are not about the winding up ones that we still have, right? And actually, if you look at Section 246 of EH-REIT, that makes it very clear. It allows the involuntary winding up of a foreign company and any partnership, association, and now I've added club in because that's what EH-REIT did in 2020 when it came to force. The word club wasn't there before. It does not include a company incorporated under the Companies Act. So if you're incorporated under the Companies Act, you go under the Winding Up Act provisions there, right, for incorporated companies. There was also something else that has been taken away. It used to apply to just, you had to have a minimum of 5 members. Because if you look back to some of the old textbooks, I think this is Alfred Emden, right? Practice and Forms and Winding Up Companies, 1988. They said that the legislature did not want to use the expensive machinery of winding up when the number of shareholders was too small, right? So there was a minimum of 5 persons, but ACRA has removed that. Why? And it's close, I think ACRA is quite clear in what it's doing, because today many special purpose vehicle, and we are a major financial center now, needs to have this provision cover the winding up of not just these special purpose vehicles in the financial sector, but even perhaps clubs, and that's why we've added these provisions in there. But even before clubs were there, the word association was already very broad, right? It included unincorporated associations, joint stock companies, building societies, loan societies, and allotments. So it included many, many things. The problem was that Brian Greene, who was, I think, once an academic, and he wrote this in the Modern Law Review, he was LSE, but I think I've seen his name recently arguing before the SICC, so I think he's now a litigator from overseas. He said that the unit trust is not an association, right, given that it's not an unincorporated association. However, he admits that associations in the nature of trading companies, and that's what our business trusts and REITs are, right? They're more trading associations than unit trusts. They are included. And he refers to this case, which St. James's, which I think everyone refers to. And our Chief Justice, Wee Chong Jin, the then Chief Justice, also relied on this case to exclude clubs from associations. So associations was accepted to be of very broad remit. It did include only clubs. But as a sign of what ACRA intends, 3 years ago, coming into force, I think, it was 2018, right, when EH-REIT was first drafted and came to force in 2020, they then included clubs in this provision as well, which means that they want to have as many entities possibly under these winding up provisions. Right? In any case, Business and trading trusts are in that sweet spot where they don't have to incorporate, because you know that Section 70 requires associations to incorporate with more than 20 members, right? But we also know the case of Smith and Anderson said that commercial trusts don't, right? They can carry on without being incorporated. At the same time, they're also considered unregistered companies under these winding up provisions due to things that have been slowly inserted from 1849. But what about scheme restructuring? Because this is about winding up. Right? So there's a slightly different story about schemes, and here I'm indebted to Professor Wee Ming Sing because he has written on the history of the scheme. I think it's in the Law Quarterly, but my memory is not very good. But you can talk to him about this during the break. The scheme itself, with respect to registered companies, and these are registered companies, only came about in 1862. So there were no scheme provisions at all in the first few Joint Stock Companies Act. But this was the first Companies Act that was passed in the UK. Interestingly enough, the scheme could only be done in a winding up. So it was not a standalone scheme of arrangement. It had to be linked to a winding up. And for those of you who have struggled with the requirements for a scheme, right, it's half in number and 3/4 in value, right? It was much easier then because it was 3/4 in both number and value for creditors if you wanted to do a scheme. It was only in 1870 that it became the requirement that we see today, which is half in number and 3/4 in value. And there's always a chance that we make a mistake with that, right? And it was also then more clearly allowed for unregistered companies because it was extended to unregistered companies then. But it was still linked to a liquidation. It was then only in 1907 that the scheme could proceed on its own without being linked to a liquidation. And these were then slowly, progressively amended, made clearer. There was a 1929 Consolidating Act. And then finally, this was put in the 1948 Companies Act in the UK, which became our Companies Act, which we call now the 1967 Companies Act. I'm not sure why we've done that, but we've gone back to call it the 1967 Companies Act. So what does this say? It's actually very simple. It says company means any company or society liable to be wound up under this act, right? So you want to do a scheme of arrangement, it applies to companies, and it applies to any company or society liable to be wound up under this act. And what is liable to be wound up under this act? That includes unregistered companies that can be wound up involuntarily under Section 246 of EH-REIT. And I like to believe that draftspersons of the 19th century saw a need to provide for claims against a partition fund. Right? They knew that they needed to, there were so many things that were still operating as co-partnerships. Right? These were then considered unregistered companies, and you had to provide for claims against them and also their winding up. Right? Even if winding up a trustee is possible compared to the trust, it requires considerable intellectual effort, as we have seen in Australia. Right? And in any case, we have seen that there are still issues that have been left unclear after the High Court of Australia decision. And if you want to restructure, even more complications because you have possibly even more disparate claims going on when we are talking about a restructuring. So, trusts and companies, I think we still have to maintain the story that they're still different, right? They're not the same. And they're different for two reasons, I think. One is that in trust law, we have this duty of impartiality that applies to trustees, and therefore that duty of impartiality means that they cannot take as much risk as a director in a company. Right? Stephen Schwartz himself, who writes on business trusts in the US, admits that. Right? He says even US business trusts are meant for securitization, where there's a steady stream of income, rather than industrial or manufacturing business, right? Which is a separate thing and requires more risk-taking. The corporate form is better for that. The other thing that has been written about now in the US is that a trust is more purpose-driven, right? You all know that, there are people trying to save the world now with ESG and so on, and they're applying this to all businesses. But some of us believe that it should only apply to investors rather than investees, right? So you've got investor companies like hedge funds, right? The GIC. These are more amenable to having a purpose written into their constitution to observe ESG and so on. And it's actually far more difficult trying to see ExxonMobil, for example, adhere to these things, right? But I should leave this story to another day because it's Ernest Lem that has written a lot about this, and so if you have any questions about that, you should ask him, right? But certainly there's still differences between trusts and companies. What we have is a spectrum of intermediate or hybrid interests and entities, right? So you've got some things which are fully proprietary, some things are not so proprietary, some things which are full separate persons, and others which are not full separate persons. There's a whole series of, there's a whole spectrum, right? And nothing is binary in that sense. And since we have now said that asset partitioning is about committing a fund to creditors in priority to others, it must be capable of liquidation, right? Because this is what commercial people expect. If you don't have that, you're going to find that in the next round of transactions, your credit is going to dry up, or the cost of borrowing will go up, right? And I think Ming Sing and I have written about this as well, how we have to maintain the shareholder balance and creditor balance correctly, because if you give shareholders too many rights, you're going to find problems with creditors in the next round of bargaining. The other thing that we've said so far is that you've got disclosure rules and mandatory rules, right? Disclosure rules work when things are not that common yet, right? And so with things like trusts, they only work in what I'm saying now because you have disclosed to the various necessary parties that when you borrow money, you are you are not going to commit your own estate to the loan, but rather you are committing the trust fund to the loan, right? So you must tell your creditors that. But more than that, you must also have something in your trust deed that makes it clear to the beneficiaries or the unit holders in the case of a REIT that they're going to invest in this, but they must give authority to the trustee to commit the fund in priority to whatever equitable interest or claim they may have, right? Now, all this, like I say, works when you disclose this, but if it's going to become more and more used and more widely accepted, the best way to do this is to legislate for it, right? And this is probably as far as we can go in terms of a trust legal persona. There's a danger now, and this is something that some academics have written, like Zhang Tai-Tu, right? That our personal preferences, our belief that we should have the freedom to craft whatever terms of a contract that we want, but not just that, to craft whatever kind of constitution in the business that we want, right? You take a risk that you are damaging that institution because people trading with this institution will lose faith and confidence because they won't know what those terms are, right? And at the same time, I say disclosure is important, but we also know that there are people fighting against disclosure using privacy arguments there, right? So if we want things to work, it's either got to be disclosure or it's going to be mandatory terms. I prefer using disclosure because I prefer giving freedom to people to negotiate. And I think what has happened with REITs in Singapore is a good thing, but I think we'll be very careful not to go too far. Thank you.
Members of the audience, if you have any questions, please raise your hand and we'll pass the mic to you.
Hans, thanks very much. As usual, fantastic and very comprehensive. Andrew Chan, Allen Gladhill. My question is this. Essentially, the point of which you're actually making is that if you've got partition assets or whatever, that you should have a means of, I suppose, winding up as well as restructuring. Let me just postulate this thing, because I do think that there is already an existing possibility, which is that the existing possibility arises, I mean, insofar as what you call winding up, I have no problems that, I mean, there is an argument that that's an unregistered company. Insofar as the trust is concerned, I think insofar as schemes and judicial management is concerned, because it has additional requirement, you need to be a corporation. It's not just any unregistered company, and hence you cannot fulfill that. But the point or the proposition which I'm putting forward is this, because I do think that a lot of the contracts out there where trustees, the REIT trustees, or even the business trust enters, it says, I shall not be liable, you look to the assets only. I think the proper construction is not that I've got no obligations, but really it is actually a limitation in terms of liability. Such clauses, properly interpreted, should not mean that I got no liability. For example, if that was the case, I can just simply, what they call fraudulently do off the assets, you've got no claims against me. Because insofar as the trustee has got legal capacity, insofar as there's some obligations, insofar as there could be possibility of a contingent claim against a trustee, that to me is a sufficient foundation for the trustee to be the party who will propose a scheme, or I suppose we may not want to put this out to judicial management, but that's a separate question altogether. So it seems to me leveraging on the position of trustee, leveraging on the fact that the clause seems to say you look to to the assets itself is not necessarily precluding, if you like, liability as debtor, albeit contingent. It seems to me that perhaps the persona of the trustee could be a means of achieving your restructuring. Your thoughts, Professor?
Thanks, Andrew. As usual, very difficult question. You're right. So there have been people like John Armour who have said that for a long time the trustee was the persona for the trust fund, right? And you can, in a sense, work that way. But I always say that when it comes to difficult issues, you're going to find people challenging what you've just said, and there might be issues that arise that cannot be fully resolved. So some of the things that come up, which is hard to visualize in the situation that you talk about, but will come up when you talk about a trustee that's a trust fund and all these things are contractually done, is that you've always got a pari passu rule, you've got anti-deprivation rules. I can't visualize how exactly it works in this context, but what I do know is that these rules will never, at least given our knowledge now, will never fully be stabilized, right? So the pari passu rules, for example, sometimes depends on how badly the debtor behaved, right? The anti-deprivation rule depends on good faith and so on. So if you want to do this, yeah, you can, but I'm not sure that you won't encounter some problems when you're looking at the three-party situation, because every time there's three parties, and I think you always use the word mutuality that comes up, right? There will always be problems that happens if you don't see that separate entity where all the claims congregate. Because you're saying that the trustee can represent the trust fund, and I agree. But the other thing that I worry about is how is the trust fund committed to this? Because we are in a common law jurisdiction, not a civilian jurisdiction, where the trustee is the absolute owner of the property, right? So they have trusts in civilian jurisdictions as well, where we visualize the trustee having a certain patrimony and a separate patrimony of its own, right? And they are the absolute owner of the thing, and so they can commit the fund. But you are the legal title, you only own the legal title in Singapore, in the Commonwealth, and as trustee, I'm not sure you have the power to commit the fund that way. What we do know is that you have the power to give security over the trust fund, right? So in these cases, there's never been a problem really if you have a mortgage or charge over the trust assets. The problem has always been with the unsecured creditors, because how do you commit that to these trust creditors without that separate entity in the case of a company? So I agree that you can do quite a lot with drafting, quite a lot with trying to visualize perhaps that the trustee and the trust fund are the same, but I would say that it is still easier in the end to work it out at the trust fund level. And certainly with these things like the rights of exoneration, right of indemnity, we've not fully sorted out, right? And then what about all the priorities with preferentials and so on? Do those provisions apply? We don't know for sure.
I have a number of responses, but I want to give the opportunity to the rest. I suggest that the case of Penwith may provide a solution, because there's a question of mutuality. They say it's on one hand, vis-a-vis the trustees, because we look at it in substance, right? What is mutuality? It means basically your cross claims, but you look in substance who is actually beneficially entitled. So in one hand, you have the obligations to the creditors, but at the same time, it's a personal obligation of the trustee. And at the back, the person's entitled to it is actually the beneficiaries. But the court in Penwith was able to reach or find mutuality on the basis of the right of exoneration back, because the substance of the obligation to the albeit personal to the creditors, when you look back behind the trustee itself, he had the right of recourse to substance back to the trustees, hence the right of exoneration indemnities, and they found mutuality in that particular purpose. But anyway, that's a topic fighting for further discussions. I don't want to hold anybody else.
Thank you, Professor Tjio, for the excellent lecture. I'm Clayton Chong. I'm a restructuring practitioner from Wong Partnership. And similar to Mr. Chan, I'm also trying to think of solutions, right, to address the issue. So one technique that's been developed over the past decade or so, which has been endorsed in Singapore in one of Justice Eddie Abdullah's decisions, is the use of a separate entity, right, where which executes a deed poll that assumes the liabilities of the company that is owed the debts, right? And then that company is the one that proposes a scheme of arrangement. initially, this started as a technique for forum shopping, right? In order to establish jurisdiction, for example, if in a country which has a scheme of arrangement provision, if the underlying companies actually don't have access to that regime. So I was wondering whether this potentially might be a technique that you can use also to address the issues that you face, because it does provide a way to, through an indirect means, partition the assets, right, as well as subject the liabilities within, segregated entity. And the liabilities that we're talking about here, building on Mr. Chan's suggestion, would be the liabilities of the trustee itself.
Yeah, thanks very much. I'm not an insolvency expert, but what you say sounds like it is possible to sort of hive it off, and then you do the scheme at level. But in my many discussions with Meng Sing, who has educated me a lot on these things, it is true that the scheme is a very flexible device, right? And you deal with whatever the scheme issue is, but that might not deal with the underlying business that needs to be restructured as well. So if you're talking about restructuring some of the liabilities with the bondholders and the unit holders and all that, that's fine. But if there's an underlying business that needs to be restructured as well, because there are employment contracts and so on, my guess is that it's going to be very, very messy trying to do all this at this other thing, which is great for, it's tidy only if you're dealing with very clear-cut liabilities like claims of bondholders, some banks, and so on. But if you're really talking about restructuring the underlying business as well, and not just the bonds that have been issued, I think you need to go and try and find something at a greater underlying level. And that ties up to something else, which is that, yeah, there's restructuring around the world that's going on at that level with financial instruments, but they've always got to be very careful that the restructuring does not contradict the restructuring that's happening at the corporate, at the business, the real business level, right? So that's I think I agree that something can be done at that level, but I would still say that isn't it ideal, and it also preserves value, right? If you can have one forum, one place, and one entity, that everything is restructured.
My role is just to manage the Q&A. I don't see any unruly people here. So it's more to make sure that people get a chance to ask. And since nobody is asking, Prof, can I ask a question? You mentioned legislation. Any ideas broadly on what you think is the best way to achieve that?
Okay, I think the Australians are looking at it now. So the Australian Law Reform Commission, I think in December last year, said they were starting to look at this issue, because I think Carter Holt-Harvey has shown that it's difficult. One piece of legislation that did come out of New Zealand that has been passed, unfortunately they didn't do it at the entity level. What they did was they strengthened the right of indemnity or exoneration. So that problem is that, I don't have the diagram here, but that right of indemnity of exoneration that the trustee has, that the creditor subrogate itself to, can be lost in quite a few circumstances, right? If the trustee acts without authority or with some kind of negligence, that thing disappears. And once it disappears, it's not the trustee that's punished, it's actually the trust creditors who can't be subrogated to it anymore. So what the New Zealanders tried to do was to say that even if the trustees don't have the right of indemnity anymore, it doesn't matter. The trust creditors would still have that notional right of indemnity to subrogate itself to, and so therefore it becomes more like a direct claim against the fund. So I guess that's one possibility, to craft it in such a way that it's sort of divorced from what the trustee has against the trust fund, and then it becomes like a direct claim of some sort against the fund.
Simon Jessamine, NUS Law. A very elementary question, which is, and it sounds like this is mostly sophisticated players involved in this, and there's a degree of uncertainty. So really elementary, why are trust creditors lending in the first place? And is this uncertainty not kind of priced in? In which case, are you solving a problem that the market is already addressing or not?
Gosh, okay, it's a market question. So you're right, that family trusts never encountered this issue because the trust was supposed to be a wealth holding device, right? Not a business. And as such, you own assets, you don't really borrow money to build assets and so on. So it's really with these REITs that have large properties and they start developing that this thing happens. I don't know. I mean, the practitioners here who do REITs can tell us whether it's priced in. My guess is that it's not really priced in because the REITs are pretty large institutions, or they are created by pretty large institutions. And also you can't allow the interest rates to be too high because we need to get a certain return. So REITs became attractive because they were giving about a 5% return when markets were from about 20 years ago. And that only came about because they had the tax relief, right? And if you say that they had also had to pay a higher interest rate for any borrowings, that might have created problems for the tax returns. But maybe Andrew can tell us whether it's been priced in.
Okay, so the largest creditors insofar as the REITs are concerned are essentially the lenders. So number one, I mean, they could lend or they could borrow at the SPV level. So maybe you don't have the trust issues itself, but then you have a guarantee at the, let's say, the REIT particular level. So that provides a measure of safety because you have dual recourse, you have it also in relation to a particular company. Number two, now, insofar as the REITs are concerned, I mean, they are gearing ratios. So you take, so as it first came about, when the first REITs first began to borrow, the banks and institutions insisted on secured lending and secured lending only. But that was around 2002 when they began to come up. By around the 2004 or so, it became fashionable to actually have unsecured lending. And these very questions, which Hans has raised in the sense, your right of subrogation, etc., may actually be lost. But banks have taken a particular view. And here, again, there are a number of safeguards. Safeguard number one is really this. They also take other advantages. Because of the gearing ratios, they can only borrow so much. Because, I mean, I'm based on certain rules and what have you. So, in other words, this is an entity with, if you like, very stable. It's not really running much businesses. It shouldn't have much other liability. So you balance the fact of the likelihood of insolvency. But that in itself is not a full answer because you might be concerned about the fact if there's actually a lending and there's a breach of the duty on the part of the trustee, etc., the trustee might not have recourse to the assets and hence impacting the ability of the lender to actually have recourse to the funds. But there is another principle which is applicable, at least insofar as the principle is concerned, the money goes in, there is a principle of restitution. So this right, which defeats the right of the creditor to, if you like, rely on the right of the trustee of exoneration, may apply insofar as the breaches, but it does not prevent the recovery if I actually enrich the fund. So because there's also the possibility of another remedy in, the cumulative all of these people have become comfortable.
I'll just add to that last part. So when this issue was looked at in the UK, it wasn't the Law Reform Commission that looked at it in the UK, it was a King's College Trust Law Committee that looked at it. They actually said restitution was a possibility as well, right? But of course, whether it falls within one of the unjust factors and so on, but in Singapore, it looks as if it does because we have possibly stronger unjust factors in Singapore. So restitution is a possibility as well. Embry.
Thank you, Professor, for the wonderful lecture. I'm a nominee of King's College and NUS dual degree program, and currently doing CFS LLM at NUS. And I am currently in a module called Company Law, and he's my professor, and he kindly invited me to this seminar, which I'm very thankful. As I was previously studying at King's College London, I came across a very peculiar creature of English law called quis close trust, and it's about the accessibility of the funds as to normally pertaining to affiliating to the insolvency situation. I previously searched very briefly whether quis close trust existed in Singapore, and which it did. And I'm just wondering how quis close trust would affiliate to the current seminar topic and how it would work. Thank you.
Okay, I haven't taught trust law for quite a few years, so my knowledge of quis close trust is a bit hazy, but we do know that it's more likely to be an express trust, I think, than a resulting trust, although some people think it's a resulting trust. I think it was this debate between Hoffman and Millett as to which one it was. But those are trusts for a purpose, right? And if the purpose fails, the money goes back to the person who originally provides the money. I'm not sure you can discern that purpose here, because you would then have to say that the trust creditors only lent money for a particular purpose, and then so the purpose doesn't really fail here because it's being used for the purposes of buying property and so on. And so very difficult to see the thing coming back to the original creditors, because in fact what they wanted was fulfilled. It's just that they want to be able to claim it back under some kind of restitutionary basis or just claim on the loan itself. So I would say quis clause only works when the original agreement fails, and then you find a way of either saying that the express terms allows it to come back to you, or it was always with you, or it results back to you. Right? So very hard to use the quis clause trust argument here, I think.
Professor, my name is Ekin. I'm a corporate finance advisor for Reits in Singapore. In my past life, I was a corporate lawyer. So I just want to ask, and my question might be a bit more practical, so maybe Andrew might know. Have you considered in your analysis if there was any difference between internally managed trust and externally managed trust? Because the assets that will be seized will include the manager, right? So for example, the US jurisdiction, do you think that in your analysis it would be neutral, or that there could potentially be a difference? Because at the end of the day, we talk about the living and breathing thing, the brains behind the whole trust structure. And in Singapore, it's all externally managed. But in Australia, we do see quite a fair bit of internally managed, and in the US as well. So would that make a difference in terms of your analysis? I'm not sure if you have considered.
Okay. I'll just answer very quickly, and then Andrew can provide more details. So with the internal managed, it could be so internally managed that it's actually a corporation. So for example, the REIT in the UK is a corporation, right, with tax advantages. And many mutual funds in the UK, the US, when they say internal management, they really mean that this is a mutual fund corporation with its own board of directors and it's a company, and then you have no problems at all, right? The Australian one is more difficult because they have the managed investment scheme there. And their idea of internal management could still be a trust structure, but it is a very, very strong situation where they've created this managed investment scheme provisions, which actually I would say is like a company minus type structure. So it actually could be seen almost like a corporation, and in which case, you can restructure it like a corporation as well, right? The difficulty for us in Singapore is that our Business Trust Act was, in a sense, modeled after the managed investment scheme provisions in Australia, but not fully. We only provided the liquidation of business trusts in one way, which is that it's in accordance with the trust deed. We didn't go further and talk about the winding up of this business trusts voluntarily or involuntarily and so on. So it was, in that sense, a partial project. So yes, I would say, in fact, some people would say that our business trusts are internally managed, but I guess they're not sufficiently internally managed to view it as a corporation and to be restructured that way. Andrew?
So the point you raised is excellent. Excellent for this reason. See, one of the concerns essentially is that the right of exoneration or right of trustee is lost if the trustee is in breach of the trust. Now, insofar as REITs, and there's a distinction to be drawn between REITs and business trusts, typically there's a manager. The manager is the one who makes all commercial decisions. Now, insofar as the trustee is concerned, unless they knew there's any wrongdoing, if they just simply follow the instructions of the manager, the trustee acting in good faith itself is not in breach. Because it is not in breach, and it is a trustee who is actually borrowing, the right of exoneration or indemnification is not lost. So it makes a difference that you have this dual separate structure in the case of a REIT between the manager and the trustee. The trustee manager is a bit more tricky because it has both roles. So in those particular roles, because you're a trustee, also manager, this particular rule apply because you're now the manager, and insofar as this is concerned, because you breach your duties as manager, does that impact the right of subrogation as yourself to trustee? That's a bit trickier. But another argument, therefore, in the context of REITs, which we put forward, is that, look, this loss of the right of exoneration and what have you, which is premised on the trustee being in breach, is largely mitigated by, there's Professor Chesterman's question, by the fact that they have to act on instructions. And hence, where is the breach on the part of the trustee, and where is the loss of the right of exoneration? So it's a good point, good question.
Can I just follow up on what Dean Chesterman raised earlier? Like Hans, I don't think the trust creditors have really priced it in. I won't claim to be expert on this, but I don't think they have. But I'm interested, are there representatives from banks or advisors to banks? Do trust creditors really think that hard about the difficulties of being a creditor to a trust? I'm not sure.
You're shaking your head, so they don't.
No, because, you know, you have that reputation, and, you know, the Singapore REIT has done very, very well for itself. So they don't actually examine the legal intricacies of that.
Yeah, that was my guess as well.
Yeah.
We tend to look at it as, well, this should be safe, this should be good, returns are good. But you don't think about, it's almost like a marriage, you don't think about divorce.
So trust creditors who are banks, what I've actually explained earlier, we have advised them a number of times because there's huge amounts. Creditors who enter major transactions, we get asked, but the run-of-the-mill creditors, they don't care. So I think that is, so it's really, I think, a question of sizing, and it depends on what kind of regulatory or other requirements sort of this. I mean, insofar as the beneficiaries are concerned, I mean, do they think about these kind of things? In one sense, as far as the unit holders are concerned, if there's a loss of the right of exoneration and what have you, and therefore no recourse, potentially this is actually good or better for the unit holders because the creditor will have no recourse.
Hi, Joe Chung from Wong Partnership. Professor, thank you. Just to latch on to Justice Chua's question, I think historically the creditors haven't really thought about what their rights are in restructuring or insolvency scenario for business trusts and collective investment schemes. But after Eagle Hospitality Trust, they're starting to. Anecdotally, I think we have seen queries, and they are very targeted queries on how their positions would be protected or compromised or cramped down, right, in a restructuring or insolvency scenario.
Yeah, because now with the cramp down provisions for schemes, you're talking about rights actually clearly being extinguished, right? So the Eagle Hospitality Trust, I don't really know what happened. I know that the beneficiaries, the unit holders didn't have anything, but did the bondholders still get something out of it?
I can't recall offhand, actually. Yeah.
Because actually, although it was called a restructuring, effectively it was just a controlled sale of things, right? And Chief Justice Sonchi did it very quickly, right? But I think they were trying to keep as much value there was, but I think all the creditors took a hit, right? Yeah.
From what I understand, most of the portfolio was downstream, it was all mortgaged. I think the secured lenders actually took the bulk of it. And the restructuring was more seen as a winding down kind of procedure.
Bill Jameson, CNP Law. Would it not be simpler just to use a corporate vehicle and not have to worry about all this?
I fully agree. In fact, that's what the UK has done. They examined all this, and then I think in 2005 they decided that the UK REIT would be a corporation. And then 40 years ago, the most famous of professors in the areas that we are in, Professor Harold Ford, said that he called the business trust a commercial monstrosity, I think. And he said that the best way to do this is to make them incorporate, right? It can't be that difficult. The thing in Singapore is that they thought that if you became a corporation, you would have had corporate tax. But I would have thought the easier way is to let it be a corporation and then give it tax exemptions as a corporation. But that's something you'll bring up with the Inland Revenue, the IRAS, right? But you're right.
Yeah, thanks for that. I was going to ask whether we should look at some structural reform rather than trying to attack problems at specific areas. We seem to be struggling with problems caused by the different concepts and what I call the hybrids, and trying to apply our principles that we apply elsewhere into these new hybrids, which is never a tidy solution. And speaking personally, I always feel that, yes, great sanctity of contract, autonomy of contract, between two parties, go do what you want. But once you move away from the private sphere into a more public sphere, and here I talk about involving a lot more people, I think a legislative scheme makes it much easier. All right, there are no other questions. I'm sure you agree with me that we've all gotten more than we hoped to get. And a big round of applause to Prof. Hans-Georg.